It's me again here with your lecture video for assignment number 26, where we're going to talk about Congress's powers to tax and spend. Now, there are actually a number of constitutional provisions that relate to taxation. The power we're going to be focusing on comes, as with the other powers we've talked about with Congress, from Article 1, Section 8. And this is where Congress is given the power to lay and collect taxes, duties, imposts, and excises. It also gives Congress the power to do some things like pay the debts and provide for the common defense and general welfare of the United States. It's sort of worth noting that nothing in this section of Article 1, Section 8 explicitly talks about the power to spend, other than that we can pay our debts and that somehow are able to provide for the common defense. But it has always been sort of accepted and assumed that this is Congress's taxing and spending power, because even today in our crazy post-spring break world, we have never forgotten that it is a constitution we are expounding. There are some other provisions, however, in the Constitution that affect the taxing power as well. These other provisions include Article 1, Section 9, which tells us that no capitation or other direct tax shall be laid unless in proportion to the Census of Enumeration, herein before directed to be taken. As I said, this isn't going to be the focus of our discussion, but it's still interesting that we have this evolution in the Constitution where, to pay for the Civil War, the United States imposed a federal tax on income for the very first time. At first, it just imposed a 3% flat tax, but it later changed that to a graduated tax. And in a case that the court heard in 1895, the Pollock versus Farmer Loan and Trust Company cases, the court ruled that having a federal income tax on income from property, not all income tax in general, was unconstitutional because they found it to be a direct tax and said that it was unapportioned in violation of Article 1, Section 9. So this eventually led to the passage of the 16th Amendment, which tells us that Congress shall have the power to lay and collect taxes on income from whatever source it is derived, without apportionment among the several states and without any regard to the census or enumeration. So the 16th Amendment actually brought about a really huge increase in the power of the federal government, because once it was able to tax income from all sources, it now really had some real money that it could spend, and it started to do so, including doing things where it attached strings to that federal money. The power of Congress to raise revenue through taxation has essentially been found to be unlimited, other than this requirement that it be uniform throughout the country. But there has been some question about when and how Congress can use taxation, and particularly how can it use, or if there's a line between taxation and Congress trying to use taxation as a penalty for regulatory purposes. So I'm just going to talk a minute about this case I didn't have you read. It's actually not even in our book, called Bailey versus Drexel Furniture from 1922. And this case came about in response to the Hammer versus Dagenhart case, which we talked briefly about when we were talking about the Commerce Clause in our pre-New Deal era. And that was the case in which the court said that Congress couldn't regulate the use of child labor through its Commerce Clause powers. So in response to that, Congress decided that it instead would pass a tax that would tax companies if they shipped in interstate commerce any goods that were made by child labor. And the court rejected this. It was an 8-1 decision. They said that this law was unconstitutional. The court said there is a difference between taxing for the purposes of raising revenue and taxing for, as a means to regulate. So they indicated that there is a line, there are limits on the taxing power if it crosses the line into regulation. Now, of course, this question is only relevant if we're talking about Congress taxing an activity that doesn't have the power to regulate under some other power. But that raises this question of what kind of power is the power to tax and spend? Is it an independent power, or is it something that is linked to the other powers that are given to Congress in Article 1, Section 8? So in another case that I didn't have you read, called United States versus Butler in 1936, the court considered this question. Here we had a challenge to a New Deal program. It was called the Agricultural Adjustment Act. It sought to stabilize production in agriculture by offering subsidies to farmers to limit their crops. And it also included a provision that would tax farmers if they produced over their allotted limit. Now, of course, at the time that this case was decided, this is 1936, so it's a year before our switch in time that saved 9, the court was enforcing a number of limits on Congress. So this question raised, or this case raised the question of the scope of Congress's taxing power, and also the question of state sovereignty in considering the federal government's taxing power. And we saw the court grapple with two competing views of the taxing and spending power that go back to the framing of the Constitution. First, there is the view of the power that was championed by James Madison. And he said that the power given to Congress to tax and spend only allowed Congress to tax and spend as a means to carry out the other powers that are provided to it in Article 1 of the Constitution. Something that was perhaps more akin to the necessary and proper clause. Otherwise, he said, this power would be much too overly broad and give the federal government much too much power. Hamilton, on the other hand, said that no, the power that Congress has to tax and spend is a power that allows them to tax and spend independently for the general welfare, that it is listed as a separate power and it is meant to be, and we should consider it as an independent, separate power. So in this case that I was just talking to you about, the U.S. v. Butler case from 1936, the court adopted Hamilton's view. They said the power, while it's not unlimited, the limits are set by the provision itself, not by the entire section, Article 1, Section 8, that it appears in. And they said there's no debate that this is within the act at issue in that case was within Congress's tax and spend powers. So for modern purposes, our holding here is that the court continues to accept this Hamiltonian position that our so-called spending powers, tax and spend powers, the Congress's powers to tax and spend, these are an independent power and they are not restricted to the scope of other regulatory powers. We also often don't get that many challenges to Congress's power to spend because there is frequently a problem with standing, that it's difficult for anyone to be able to claim standing to challenge a spending power because of the prohibitions on taxpayer standing. Thus, this is an incredibly important power that Congress has, and it's also one that is rarely challenged. The most recent challenge we actually have to Congress's power to tax and spend under the Constitution is the Sabri versus United States case from 2004, which you read for this assignment. And this case involved a challenge to a federal law. It was actually 18 U.S.C. section, literally 666. And it was federal law that makes it a crime to bribe any government official if the government entity receives more than $10,000 of federal benefits. And Congress relied on its constitutional powers to tax and spend, to its spending power, to enact this federal law. And it was challenged as unconstitutional on the argument that it doesn't require that there be any kind of link between the bribe that is at issue and federal money. But writing for a unanimous court, Justice Souter said that there is a sufficient link between Congress's spending powers and criminalizing bribery. And what he actually does is bring together both the necessary proper clause and Congress's spending powers. And he says that Congress can spend to promote the general welfare, as we just talked about. And he says under the necessary and proper clause, it can also regulate in a way to make sure that the money it's spending is not, quote, frittered away in graft or on projects undermined when funds are siphoned off or corrupt public offers are derelict about demanding value for their dollars. And he also rejects the argument that Congress should be required to make sure that there was proof of a link between the money that was at issue in this bribe, federal money that was spent, and the bribe itself, so that we will be sure that the bribe is actually affecting federal spending, because he says, and the court says, money is fungible. Bribery just doesn't work that way. It's not a dollar for dollar business. It's still really bad if officials are accepting what he calls general retainers, where and when and how exactly the money makes its way to the federal official can come in a number of different formats, and this is a completely rational way for Congress to want to address this problem. But as with the Commerce Clause, this raises the question of whether we have now given Congress an unlimited power. If dollars are fungible, does that mean that really there's almost not anything that is beyond Congress's spending power? Justice Souter points to the fact that this law does put a threshold on the amount of federal dollars, showing that that was at the point at which we really have this federal interest triggered. So he says that this is not just about going after, quote, liquors and cigars, but it's really more about punishing wrongdoing that has this significant effect on federal money. Justice Thomas is concurring, but he writes separately just to say that he thinks that the court is reading the necessary and proper clause powers much too broadly. He says McCulloch versus Maryland doesn't stand for a simple rational means standard, but rather he says necessary means plain, it means obvious, it means clearly tied to an enumerated power. So we know that the taxing and spending power is an independent power. We know it is a power that Congress has that isn't linked to any of these other powers that they can use for the general welfare, and also something that they can combine with the necessary and proper clause, and that we don't require a direct link between a number of laws and federal spending, with an understanding that money is fungible. The other big question about the taxing and spending power is, to what extent, if any, is the 10th Amendment any kind of limit on this power? Are there limits on Congress's ability to use things like strings on grants of funding to try to induce state action? Now, in New York versus United States, which we talked about in the last lecture, they said that trying to encourage states to take particular actions through the spending power was an option available to Congress. But there's still this question of whether they could take that power too far, to the point at which we would have a limit that's placed on it by the 10th Amendment. And the court looked at this issue in the South Dakota versus Dole case for 1987. This case involved a federal law that would give a 5% reduction in federal highway funds to any state that failed to raise its drinking age from the age of 18 to the age of 21. Now, South Dakota versus Dole in 1987 was decided before we had the modern Rehnquist court revival of the 10th Amendment that really came in the 1990s. But the court took on the question of whether or not Congress can attach strings to federal money to try to nudge the states to pursue a particular policy that Congress likes. And the court decided here, and this is a case by Chief Justice Rehnquist, gives us a four-part test for deciding when it's okay for strings to be attached to federal money going to the states. So the test in South Dakota versus Dole tells us that the conditions that must be met include that the power must be used to promote the general welfare. It needs to unambiguously inform the state about what was demanded of them so they can accurately and fairly weigh the consequences and make a choice about whether or not they're going to go along in order to get this funding. They also say that the spending needs to be germane to or related to the federal interests that in particular of national projects or programs. And then the fourth prong of the South Dakota versus Dole test tells us that the spending also needs to satisfy other constitutional provisions that might provide an independent bar to the congressional grant of these federal funds. And it's in this provision that we see Rehnquist laying the groundwork for some of the 10th Amendment decisions that were going to come in the following decade or two, because he says in this opinion that there is a perceived 10th Amendment limitation, that our decisions have recognized that in some circumstances, the financial inducement offered by Congress might be so coercive as to pass the point at which pressure turns into compulsion. Now, in this case, he says this is a relatively small percentage of some highway funding, so it doesn't rise to that level of being unconstitutionally coercive. Justice O'Connor is dissenting here because she thinks that in this case, the law fails the third factor. She disagrees that the penalty of 5% of a state's highway funds is actually related to the purpose here. She says this is an attempt to regulate the sale of alcohol, and that is something that is outside congressional powers, and that is something via the 21st Amendment is given to the states. The 21st Amendment, of course, repealing prohibition, says that the transportation or importation into a state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. So when we meet, maybe this is something we'll have a little time to talk about whether you think Justice O'Connor makes a point. Is this about highway safety, or is this about something else, a type of social or economic law that really should be the kind of thing that belongs to the states? And since 1937, the Supreme Court has not invalidated any federal tax on the grounds that it is an attempt at regulation and therefore beyond the enumerated powers of Congress. But I'm hoping we can talk when we get together for our class discussion about whether or not this makes sense, whether it makes sense to draw this line between the type of coercion that the court was concerned about in New York versus United States with the radioactive waste laws, yet still said conditional spending programs are exempt from a general anti-commandeering rule. Does it make sense to draw that kind of line to say it's okay for the federal government to try to use carrots and sticks of money to get states to do what they want, thereby getting them to pass legislation or not pass legislation? And also whether this sense about that there's a line between when you can use taxing and spending as a form of regulation could be a problem. So particularly in the world like we're in, where say we're post Lopez and Morrison, where maybe we're having more limitations on what it is Congress can do through their Commerce Clause powers. So I pose to you just a hypothetical. What if, following the Lopez decision, Congress says, okay, we can't, under our Commerce Clause power, pass a law saying it's unlawful to possess a firearm within 1,000 feet of a school. So instead, we will pass a law that says there is a $100,000 tax on the possession of a firearm in a school zone. And oh, by the way, failure to pay that tax is a felony and it's punishable with a prison term. Or if they said any states that don't have a law prohibiting the possession of a gun in a school zone won't get a particular amount of their federal education money. So do we think this distinction between regulatory and revenue taxes might become more important? Do we think it makes sense? And if the states do have a protected zone of activity, should it really matter whether or not Congress infringes upon those activities through direct regulation versus through taxation? And that's it for our discussion on the power to tax and spend. I look forward to seeing you all on Thursday, and stay safe.